The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to council and to those who are watching through our Supreme Court Live channel. We welcome you. We have read the briefs of counsel and look forward to hearing their arguments this morning. I would now ask Mr. Doug Shima, the clerk of the appellate court, to please call the 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, December 17th, 2020 consists of one case. Appeal number 119266, State of Kansas versus Erica Yasmin Arceo-Rojas, Geary County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. I would now ask counsel to please state their appearances.
Your Honor, my name is Randall Hodgkinson. I'm appearing this morning on behalf of Erica Arceo-Rojas.
And Your Honor, the state of Kansas appears by Tony Cruz, Assistant Geary County Attorney.
Thank you, counsel. Mr. Hodgkinson, you may begin your argument.
Thank you, Your Honor. This case involves not the first traffic stop that this court has seen by this particular Geary County Sheriff's Officer on I-70. It involved a stop of my client purportedly for lingering too long in the left lane of the 4-lane I-70 in Geary County. A search after that stop, after an extended detention, resulted in a discovery of a substantial amount of marijuana, and therefore my client was convicted after a bench trial of possession of marijuana with intent to distribute. And that brings us to this appeal. As the court already knows, the Kansas Court of Appeals affirmed this conviction with a fairly lengthy divided opinion between the majority and Chief Justice Arnold Berger's dissent in this case. So, Your Honor, as I was reviewing this case, getting ready for argument, I always think about when I get ready for argument, what am I going to add to whatever's been said below? And in this case, certainly, I think we've briefed this issue pretty well. And then we have the extensive and disputed opinions between the Court of Appeals here, which I think really lay out these issues very well. So I just want to highlight a couple things that I noted as I got ready for argument. So there are two parts to this, Fourth Amendment and Kansas Constitution claim, which have to do with whether or not there was basis for the stop in the first place. And then once there was a stop in this case, whether there was reasonable suspicion to support extension of that stop after the officer had completed the traffic stop. So with the first part of this, the officer in this case pulled my client over purportedly for lingering in the left lane too long. But as we've noted in our brief, the Kansas statute actually doesn't say you can't be in the left lane too long. It says you can't be in the left lane unless you're passing somebody, and then some other things. But for our purposes today, that you can't be in the left lane unless you're passing. But that's the purpose of that statute. And so the question between myself and my colleague and between the majority and dissenting opinions in the Court of Appeals is, does that statute mean that you have to pass within a reasonable amount of time or some time period, or are you entitled to be in that left lane so long as you're passing somebody? And our
Mr. Hodgkinson, is maintaining the same speed as the vehicle that's next to you. You're in the left lane and the vehicle's in the right lane. Is maintaining the same speed passing?
Your Honor, our position is that yes, as long as you're in a left lane and there's a car on the right, you're passing that car. Now, as we noted, and even as the district court noted in this case, sometimes when you're going down a 4-lane highway, you're going at not exactly the same speed all the time. And there may be situations where you're going roughly the same speed as that person on the right. I mean, all of our own experiences are, when I drive out on the 4-lane, sometimes I'm a pretty timid driver, Your Honor. And so I'm driving right there around the speed limit, I suppose. And so sometimes I'll be going down the road and I'm catching up to, a truck. and then we get over the hill, and then the truck speeds up. And so, or we may be going about the same speed for some period of time. That entire time, Your Honor, I still think I'm passing. I'm in the maneuver of there's a car or a vehicle on my right such that it is unsafe for me to get back out of the lane. Your Honor, in fact, that brings me to my point, which is I think the absurdity of the state's position in this case is highlighted by Lieutenant Stopper's opinion here, because he pulled my client over for staying in the left lane too long, but then sort of had the afterthought or after comment that the district court latched onto somewhat, also that my client got out of the left lane too soon. So in Lieutenant Stopper's opinion, my client was in the left lane too long, and my client got out of the left lane too soon.
Counsel, is it a problem? Is the absurdity, if there is an absurdity, really inherent in the state's position, or is it actually inherent in the statute?
Well, it might be in the, I mean, I was questioned at the Court of Appeals, for example, of, how long, counsel, how long can somebody be there? Is it, in this case, 3 miles was too long, 20 miles, 100 miles. And so attempting to sort of say the absurdity of mine. Now, my answer to your question is the statute says what it says.
Right.
It says,
So given that, I mean, my question initially is, what about circumstances of congested traffic, let's say, where both lanes are full? No, but it's not for passing purposes. It's just congested traffic. Is everyone in the left lane breaking the law?
I think as long as there's cars on their right, in the area, and I know the court's reviewed the video, and you've seen this, there was a car both in front or behind, at a place where my client could not, at the time that the officer started following her, could not have safely gotten over, I think. I mean, the officer's position was she never was able to safely get over, but in any case, at the time the officer says she was lingering too long, that she couldn't safely get over. So our position certainly is that as long as you're in the left lane because there are cars in the right lane in a place that's unsafe for you to get over, then you're not violating that statute.
Oh, go ahead.
Go ahead, Justice Standridge. Go ahead.
Okay, I wanted to say, I read the transcript and I watched the video, and it seems as if, and please correct me if I'm wrong, but it seems as if when the video was turned on by the law enforcement officer, there were actually 2 cars in the right lane, and your client was almost even, but just passing with the car that was lagging behind, and that during the course of those miles actually overtook the first car and then came to about where the second car was. And at this point, it just didn't seem to me, it seemed to me that there was progress in passing. And I'm just wondering whether that was, am I wrong, or is there a conflict in the, in the actual transcript versus the video? Can you speak to that?
Sure. And I agree with you, Justice Standridge, that the statute, that video reflects that idea. When I looked at it yesterday, the idea that my client's car was sort of maybe even between a certain car and another car in front of that one. And certainly, and as we pointed out in our brief, we know that our client completed passing at some point because she got past that front car at some point, turned on her blinker, and got over into the right lane before the officer had started his emergency signals in this case. So that's exactly right, Justice Standridge. The idea that, Justice Stegall, you asked the question earlier, or it just throws, it's staying the same. That's not what our facts are in this case. It's not that these 2 cars were sitting side by side for 3 miles. You're exactly right, Justice Standridge.
But what do we do with that? Here we have some video evidence that we're reviewing, and we observe most or some of what the state is basing its position on reasonable suspicion. How do we assess that without reweighing? How do we apply our standard when we're looking at that? And as Justice Standridge pointed out, it appears as if there is overtaking of at least one vehicle, if not both. What do we do with that?
So, Your Honor, given the standard that you have, I I don't think that there's a dispute about the facts here. I don't think the state is disputing the accuracy of the video. And we're certainly saying the video says what it says. And I mean, my colleague will speak for himself. I don't know that the state is arguing that that video is not accurate or anything like that. And so that being the case, I mean, we're not asking you to reweigh any facts, but as you know, under your standard review, you have to draw a legal conclusion from what I think are these undisputed facts, including the video. And I don't think you have to, I certainly don't think you have to ignore that video as you make that determination.
Does any of this matter? Because the district court found that the stop was justified on two grounds. One was this left lane business, but the other was an unsafe lane change. And the Court of Appeals didn't address that. And I don't see that that's in your petition for review. So, I mean, aren't we kind of stuck with the stop, and we ought to direct our attention over to the length of time of the detention?
Your Honor, we certainly did contest in the Court of Appeals the potential alternative ground for the stop in this case, which was following too close, because we argued my client wasn't following, or whether it was an unsafe lane change. So even if you're, and I'm not disputing here, if you would decide, for example, that the statute means what it says, which is as long as you're passing somebody, you're not violating state law, it may be that you would need to remand this to the Court of Appeals, because we did contest in the Court of Appeals that. You're right, the Court of Appeals did not decide that issue because the majority found that the lingering in the left lane provision justified the stop. So if it was the case that, now, I also think that you have the briefs in front of you, and you can decide that in the case that's before you in situations where the Court of Appeals didn't decide that, but we've certainly not waived it by not including that in our Court of Appeals, in our petition for review, Your Honor. At most, I think you would need to remand this to the Court of Appeals to decide that issue, that separate issue.
Let's focus on the detention because you're running out of time. Let me tell you my big problem. I mean, this is a close case. I think that's pretty obvious. But it seems to me that the officer's reasonable suspicion at least gets anchored by the fact that this was a 5-day car rental, and they were already 2 or 3 days into the car rental, and they still had half of their trip to go, if you believe their statements about the travel plans. And that doesn't, it seems to me that's really suspicious. And so if that becomes an objective, and it truly is objective, I mean, we don't have to rely on the officer. We know what the rental agreement said. And I know it got brushed aside by Chief Judge Arnoldberger of just saying, well, you can extend these things. But I think that's suspicious. And it seems like that serves as the foundation for a lot of the other observations made by the officer, which is where a lot of the fight happens. But I guess I feel like that rental agreement doesn't get the significance from the Court of Appeals that I'm giving it. So I wanted your response to that.
Chief Justice, I see my time is out. Can I answer Justice Biles' question, please?
Yes, certainly.
So, I mean, you've already sort of nailed it on the head, Your Honor, that there's no evidence in this case that it would have been particularly difficult or unusual to be able to extend a rental agreement. I mean, I'm the kind of person who would maybe usually get my agreement and then know how much time I want. But the fact that there's certainly no evidence in this case that I'm aware of that says that that they would have been unable to extend this or change their plans or anything like that. And in the absence of something like that, I think giving that much credence to the fact that the length of time on that rental agreement was what it was would be just not founded on the record. Your Honor, I see my time is up, so.
Are there other questions? Thank you, Mr.
Counsel,
Oh, yes, go ahead, Ms. Justice Wall.
Given the at least the split below at the Court of Appeals, even if we embraced your argument on the statutory construction of lingering, is there an argument to be had that it's still a reasonable mistake of law? After all, we've got differing opinions by the Court of Appeal judges.
Certainly, and we argued that the answer is no, Your Honor, because the language of the statute is clear. I mean, it's not that it's a reasonable mistake of law where just because somebody can disagree with it, that doesn't make it a reasonable mistake of law. You have to look at the language of the statute and say, does the statute say what the person here interpreted? Now, I mean, I understand that the officer in the case, and maybe the state in this case, is like, well, we like the interpretation of just lingering as too long, that's okay. And that maybe some judges will, adopt that kind of idea, but that doesn't make it a reasonable mistake of law. In order to say this was a reasonable mistake of law, if you did say this was a reasonable mistake of law, I mean, you're really saying just when people add in provisions to a statute that they think should be there, that's a reasonable mistake of law, and that's not the case. Thank you, Your Honor.
Mr. Cruz.
Thank you, Judge. As the court's well aware that the Court of Appeals made several findings, and the findings that it made were very consistent with Judge Roger's specific findings. One, we feel that that the Court of Appeals and Judge Roger found that the traffic stop was in fact valid. The video shows pretty much what the officer observed, and that is that this vehicle in the left-hand lane for over 3 miles. And as Justice Biles had inquired about, going the same speed is not passing. If that were the case, then a car could start on the western part of Kansas side by side by a vehicle and make it all the way to the Missouri border, and that vehicle will never have passed. And
Mr. Cruz, let's say that we go with that, and moving on to issue 2, it seems to me, and tell me, based on the facts, that he detains her for the sole purpose of writing a warning ticket, correct? That's the detention. She comes back to the car.
Yes.
He says, I'm going to write you a warning ticket, comes back to the car to write a warning ticket. And then he does what Judge Perrin on the Court of Appeals used to call the Columbo 2-step. He says, okay, here you go. You're free to go. You're free to go. And changes it into a voluntary encounter at that point. Is that true?
No. Because
well, what is
two
you're
things.
Free to go? How do we construe you're free to go?
The officer never says you're free to go. I watched the video.
I'm sorry.
Well, he handed back all of the documents and said, take care. Never told her that she was free to go. Immediately after that, she stepped out of the car. He asked her if he could ask her some questions, and she said yes. And that's when he inquired about searching her vehicle. But by that point, he had already established reasonable suspicion to detain her.
Okay, and so it's the state's position that take care is not ending the stop for purposes of the warning ticket.
Of this particular stop, no.
Okay, and so what do you make of the fact that when he asked to search the car, they have some banter going back and forth, and then she says, "Do I have?" I'm not going to quote, but something to the effect of, what are my rights? And he says, do you have the right to search it? She says, and he says, it's up to you. So is that consistent with reasonable suspicion of criminal activity to say that whether I search the car is up to you?
At that point, yes, because to search a car, you need probable cause or you need consent. So at that point, he's trying to establish consent. And if you can't get consent, that's why you call out for drug canine.
Right. Why was he trying to get consent?
To avoid having to call out a drug canine because he already had reasonable suspicion.
Okay, then he asked, is it okay for you to wait around while I call for a canine? And of course, that standard would be reasonable suspicion, right? Not probable cause.
Correct.
You can call a canine based on reasonable suspicion. Why would he ask her permission whether she would wait while he called a dog if he already had reasonable suspicion. Why didn't he just detain her at that point?
That question was never brought up by the defense, and I never asked it during the suppression because that was never
Right, but
an
I'm
issue.
saying as a matter of law, you know, not whether the question has ever been brought up before, but as a matter of law, if you in your mind as a law enforcement officer already have reasonable suspicion to call a dog, wouldn't you say it's inconsistent to ask the driver if the driver would stick around while you called a dog?
Not necessarily. I've seen quite a few cases where the officer already has reasonable suspicion and will ask for consent just to speed things up.
Well, he already called the dog before that exchange had occurred, as I understand the facts, right?
Oh, really? I listened to the video and it seemed like he called the dog after he said he was going to detain her.
I think that was the second contact.
And
Yeah, I don't understand all the numbers. They use numbers, and I'm not.
I guess I don't know about the banter at this. I want to focus your attention on what allowed what forms the basis for the reasonable suspicion. And in my discussion, I'm going to give you as your foundation the rental agreement. So to add on to that, you know, let's defend the reasonable suspicion.
Okay. You've got what the officer testified about being the short rental time, going cross country, very short time, that for them to go cross country in that short period of time was consistent based on his training and experience of drug trafficking. Then you also had the implausible travel plans of going from, I believe it was Washington, but the southern part of Washington to Cleveland and going via I-70 when the more appropriate route would either be I-90 or I-80, which is on the northern part of the US, and that's the quickest route. Then you have the discrepancy between their statements, and I know that the Court of Appeals mentioned that the video indicated that the passenger first indicated that the trip was for work. I would have to disagree with what they heard, because I heard that the passenger said they were going to Utah first and then going to Cleveland. And that's when the officer stopper said, "Oh, Cleveland, so what are you going to do there?" So there was a conflict in that. And then the defendant advised they were going to be to Cleveland for a couple of days. The passenger advised the officer that she didn't know how long they were going to stay, but she had 2 weeks off for vacation. So the inconsistencies and the implausibility of the travel plans played a big part to not only the district court, but also the Court of Appeals. There was also the issue of the third-party rental. The Court of Appeals noted, and as Officer Stopper testified, third-party rentals are commonly used by people involved in drug trafficking. In this particular case, the vehicle was rented by the passenger's husband, and the Court of Appeals actually found that fact to be highly suspicious because the defendant advised that her and the passenger were in a dating relationship. So the Court of Appeals found it extremely suspicious that the passenger's husband would rent a car for her and her girlfriend to travel across
focus
country.
here what the detective thought was reasonably suspicious? Did the law enforcement officer believe that was? I didn't see any testimony.
The third-party rental, yes.
Right, the third-party rental,
right.
but the whole thing about the husband.
Right. Just that the husband had rented the car and it was a third-party rental and he was not present. That's what he found suspicious.
I'm not going to be as generous as my colleague Justice Miles regarding the inquiry into travel plans. What is the nexus? What is the connection to ensuring that vehicles are operated safely on the road, driving in the left-hand lane, and some sort of connection to travel plans? How does that connection play a role in roadway safety? That's basically what we require prior to some inquiry about travel plans. Connect that for me.
I thought the current legal standard was that the officers were not allowed to extend a traffic stop to ask travel plan questions. In this particular case, the travel plan questions were all being asked while the officer had called into dispatch while he was waiting on dispatch.
In State v. Jimenez, we clarified that standard and said that it has to be something reasonably connected to roadway safety. How is that here?
From my understanding of reading of Jimenez, it was that there was basically two methods that the officers could in fact inquire about travel plans, and that travel plans were not inherently part of a traffic stop. But one was that they could not extend to the traffic stop. Second, if they were going to extend to the traffic stop, they had to rely on some sort of public safety. Well, the fact that the individuals in the left-hand lane and not passing anybody on a cross-country trip, and I believe there was testimony and video shown, though I have watched my video and I don't see it there, but the testimony of the officer and the findings of the district court were that there was actually, in fact, a silver SUV, and I believe it was also a finding made by the Court of Appeals. There was a silver SUV behind the defense vehicle for a period of time, and finally that vehicle got in behind the other vehicle that the defense vehicle was side by side, and when the officer passed it, that driver gave a very frustrated look at the officer, like, why are they still in that lane? So I think that's the public safety is that they're.
Mr. Cruz, isn't it true that it was that silver car that she passed in the first instance? There were two cars, one behind the other, a white car and a silver car. She was in the process of passing the silver car when the video came on. She passed the silver car, and then she was gaining a little bit on the white car, and then for a period of time was even with the white car, and then it was the silver car then that sped up again at that point. Of course, now we have introduced into the facts a law enforcement officer in a marked vehicle. But isn't that the silver vehicle that was still behind the white car that she had just passed?
All I recall from the transcript and from the Court of Appeals opinion was that it was a silver SUV vehicle. Okay. Sorry.
It's okay.
I want to raise a point that my colleague Justice Stiegel made to defense counsel, appellant's counsel, just briefly ago. In the performance of my duties last week, I had to travel to Leavenworth and be there at 8 in the morning. So I left, went down I-70, and knowing that this case was on the docket, I thought, boy, in my common experience, I see people lingering in the left lane all the time. And so as I was traveling to Leavenworth at 6:30 and 7 o'clock in the morning on I-70, I observed not infrequently cars traveling down the left lane. In fact, I passed one in the right lane. And then when I reached K7 and went over to Leavenworth, it's a divided highway. And this gets to Justice Stiegel's point. I think because of the time of day, there's commuters and it was packed, it was fairly crowded. That 2-lane highway just became a thoroughfare for both lanes to be utilized. And I would say every car in the left lane, again, not being a law enforcement officer, but was violating this statute. I mean, both lanes were being utilized. There was no distinction as to who was overtaking who, and that's what happened. What does the arbitrary nature of this statute and the enforcement of the statute, does it play any calculus in how we look at reasonable suspicion in these cases, in these individual cases?
Well, first of all, I think you have to take into consideration the specific facts of this case. There was no congestion on I-70. If it had been, we'd probably be looking at, again, completely different facts.
Well, why does that matter?
because again, you have to look at the facts of the case. For example, if there was a car that was in the left-hand lane that had a flat tire that was trying to get off on the left shoulder because it felt that it was the safest place to get off at, and it was blocking traffic temporarily, and the officer goes to pull it over because it's lingering and finds out that the vehicle was in fact breaking down or had a flat tire, then we're dealing with, again, a different situation altogether. There may have been a legal basis, but there was obviously some sort of defense. And again, it depends on the facts. I've been in traveling in high area or high traffic areas on the West Coast where it's 4 lanes of traffic in each direction. Everybody's going about 85 miles an hour, and all lanes of traffic are full, and nobody's really passing anybody, but that's just the flow of traffic. And that's what you expect to see in high traffic areas.
Counsel,
On this part of I-70, there wasn't anything.
doesn't that at least suggest the possibility that this statute is unconstitutionally vague because it doesn't provide law enforcement any discernible and objective standard by which to pull people over or not pull people over?
No, sir, because you have the same issue with the following too closely statute. One, the defense in this case never raised the constitutionality or the vagueness of the statute, so it's presumed to be.
Well, I agree with that, but I guess my question is a piggyback on Justice Rosen's question, which is, does that, let's just say hypothetically, we have questions about the constitutional viability of the statute. Does that play any role in a reasonable suspicion analysis?
I don't believe so, because if you look at the following too closely statute, it just says that you can't follow the distance that's unsafe, and it actually took an appellate court to come up with the 2-second following rule back when the speed limit was, I believe, 70 miles an hour, and now that's the legal standard. So I don't think that is something that should be considered here.
Chief
Counsel.
Justice, may I ask one more question?
Yes, you may.
At what point, based on your reading of the transcript and you being at the suppression hearing, at what point did the law enforcement officer in this case develop reasonable suspicion? Sufficient enough to call for a dog?
I believe that would have been right after he spoke to the passenger.
Okay, and based on what? What do you base that conclusion on? Did he testify to that, or? I mean, how do we know that?
There was no testimony as to when specifically he developed reasonable suspicion, but he advised he developed reasonable suspicion before he handed her documents back. But he just had his list of factors. And the reason why I base that on that specific timeline is because that would have been the time period where after he spoke to the passenger and found out that their travel plans did not match. Up until that point, he had already spoken to the driver about her travel plans, had observed his duffel bag, had a smell.
Right, okay, and then one follow-up question. When you're looking at all the circumstances and whether there's reasonable suspicion, do you also look at the parts of the travel plans that do match? I mean, I know we've kind of pinpointed out the ones that don't match. Do you also take into account, because there were quite a few factual statements made by them independently that do match? Should that be taken into account by a law enforcement officer in determining whether there's reasonable suspicion?
No, Your Honor, because I believe that the case law is that according to, I think it's United States versus Arvizu, that the officer doesn't have to dispel reasonable suspicion or take into account what may be construed by some people as innocent behavior. as long as what he or she is observing falls in line with what they're trained to observe, and if they believe it to be reasonable suspicion.
And what,
Otherwise,
could you tell me that case again?
it's Arvizu, ARVIZU.
Okay, thank you.
I believe it's cited in my appellate
That's
brief.
fine.
Are there other questions?
Thank you, Chief. If I may.
Yes.
Go ahead, Justice Wilson.
To the question of congestion, counsel, and the facts of this case, does it make a difference if the congestion is caused by what I'll call the passing driver?
I guess I don't understand the question. Sorry.
Well, I believe there was some testimony by the law enforcement officer that the car on the right was coming up and made a face or movements of frustration to the officer. I believe that he inferred that that driver on the right behind the front car was frustrated for some reason. Does it matter if the congestion that may be on the highway was caused by the driver who's...
That I believe so, simply because if the congestion is being caused by the driver or the driver that's not passing, then that would be, to me, indicative of the fact that they're in violation to the statute because they're not passing, they're causing the congestion.
Can you help me understand? You suggested there was inconsistency between the driver and the passenger stories, and I want to flesh that out in a little bit more detail because on balance, it almost seems that one may provided more detail than the other. But what factually are you hanging your hat on for the inconsistencies?
Excuse me. The inconsistencies would be that the driver originally said they were going to Cleveland. The passenger advised they were going to Utah, and then they suddenly changed their mind, and ultimately they were going to Cleveland. The driver never advised the officer about them going to Utah first as their original destination plan. Then you get into the situation where the defendant advised the officer that they were going to Cleveland for 2 days, and the passenger advised that she didn't know how long they were going to stay there, but she had 2 weeks off, and according to the rental agreement, they would not have time to be there for 2 days before the vehicle was due back in the state of Washington.
So the first part of that was the fact that the driver didn't mention that their original plans had changed, which was the passenger story?
Correct.
And the second part was the driver saying that they would stay a couple days, but the passenger saying she didn't know exactly how long they were staying, but she had taken 2 weeks off.
Correct.
Any other questions? Mr. Cruz, would you like a few seconds to wind up?
Yes, thank you. And I know that probably everybody's saying, well, this is a closed case. This court has upheld closed cases similar to this. One is State versus Moore. It's 283 Kansas 344. It was cited in my brief. Also in that particular case, the defense was relying on DeMarco. One of the things that this court in Moore distinguished DeMarco from the facts in Moore is that in Moore, you also had a masking agent that allowed or was a factor that played into reasonable suspicion. But one of the things I want to take into consideration is that recently in Kansas versus Glover 140 Supreme Court to 1183, the U.S. Supreme Court advised that the standard of reasonable suspicion depends on the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. courts cannot reasonably demand scientific certainty where none exists. Rather, they must permit officers to make common sense judgments and inferences about human behavior, noting that an officer need not rule out the possibility of innocent conduct. Also, in Hine versus North Carolina, because this is a Fourth Amendment issue, the premise here is that the stop and the detention had to be reasonable. In Hine versus North Carolina, the U.S. Supreme Court advised that to be reasonable is not to be perfect. So, given the findings of the district court, the findings of the majority of the Court of Appeals, I would ask the court to uphold that the traffic stop and the detention. Thank you.
Thank you, Mr. Cruz. Mr. Hodgkinson, you reserve 3 minutes.
Thank you, Your Honor. Just 2 points in my short time. First of all, with regard to the stop itself, and Justice Rosen and Justice Stegall, sort of to your point, yeah, we didn't challenge the constitutionality of this traffic statute because I don't think it's unclear. I think, if you interpret it as we are suggesting, as the plain language says, then it's not vague. If I'm passing somebody, if there's somebody in the right lane, whereas I'm in the left lane, then I'm not in violation of the statute. But if you construe this statute as the state would suggest in this case, it's going to raise those vagueness problems, those arbitrariness problems. And it's going to be a situation where every time anybody gets in the left lane of a 4-lane highway, they're doing so at risk of violating this statute, because who knows how long is a reasonable amount of time for some drivers. I have a number of colleagues who work in Topeka and live in Lawrence. And I've heard a lot of stories, sort of like yours, Justice Rosen, of frustration of people who think you should go faster, get out of that lane, whatever the situation is. But that's not what the statute says. The statute is clear and says if you are passing, if somebody's in the right lane right next to you, you're not in violation of that statute. To the second point regarding whether or not there was reasonable suspicion to detain, this court has explored and is cognizant of some of these issues. I just wanted to point out, and I thought it was really helpful, Chief Judge Arnold Berger pointed this out when Lieutenant Stopper in this case was asked about, what were your reasons for thinking maybe that these were drug traffickers? This is Lieutenant Stopper's comment. This is at page 17 of Record 7, talking about generally they make short, fast trips. That just limits the exposure to law enforcement. They're generally, a lot of times, they'll use vehicles registered or rented in somebody else's name. The list is endless as far as the indicators of criminal activity, if you will. And I think, I understand that from Lieutenant Stopper's perspective, that may be the case. But even going back to what my colleague just said, I mean, we don't, and we shouldn't, and I hope this court doesn't judge the validity of a stop based on what a suspicious officer thinks, but on what reasonable people would think. And when you apply that factor and that standard to this case, we hope that you find that the officer would not have reasonable suspicion to detain Ms. Arceo-Rojas after she said she didn't want to be detained any longer and after she didn't want to have her car searched.
Mr. Hodgkinson, very quickly, is it a reasonable person or a reasonable, would a reasonable person be suspicious, or would a reasonable law enforcement with law enforcement training be suspicious?
It's understanding that there's training and experience that's possible, but even what my colleague just quoted, it's a reasonable person. I joke with my wife a lot, if I can finish, Your Honor.
Yes, go ahead, please.
I joke with my wife a lot, because I've worked on a lot of these cases, and we'll be driving down the street and I'll see somebody walking down the sidewalk and I'll say, you know what, that's suspicious, because you know who walks down sidewalks? Drug dealers, right? That the perception of the officer may be, there are all these things that, and Chief Justice Arnold Berger does a much better job than I did of sort of listing all these things that officers will say is suspicious. They were driving too fast. They were driving too slow. They made eye contact. They didn't make eye contact. They were driving a new car. They were driving an old car. They were driving a rental. They were driving their own car. That for officers in this position, maybe it's the case, as Lieutenant Stopper says, the list is endless. But if that list is endless, that means there is no protection under the Fourth Amendment or the Kansas Constitution for people driving in this state. I hope that's not the result. Thank you, Your Honor.
Thank you. Any other questions? Okay. I thank both counsel for your arguments. The court will take this appeal under advisement. The court is now in recess until 1:30 this afternoon.